A mechanical arm paints a masterpiece while a human watches, but federal courts reject the registration. The United States Copyright Office enforces a strict boundary. Only works created by human beings receive copyright protection. The foundational rule traces back to the United States Constitution, which authorizes Congress to protect the writings of authors. The Supreme Court defined authors exclusively as human creators, excluding machines, celestial beings, and animals. In the landmark monkey selfie case, federal judges confirmed that a crested macaque could not own the copyright to its own photograph. This established that non-human entities lack legal standing under current copyright statutes. Computer scientist Stephen Thaler tested this boundary by attempting to register an artificial intelligence system called the Creativity Machine as the sole author of an algorithmic painting. The application was rejected.
Thaler sued the Register of Copyrights. In the resulting federal case, Thaler versus Perlmutter, the court held that human authorship is a bedrock requirement of copyright law, affirming the agency rejection. The United States Copyright Office issued formal guidance clarifying that platforms like Midjourney, Stable Diffusion, and ChatGPT act as tools that execute commands rather than human artists expressing original ideas. Consider the graphic novel Zarya of the Dawn. The creator obtained registration for the text and selection of images, but the individual artificial intelligence images themselves were explicitly denied protection. The critical legal distinction lies between mechanical execution and creative control. If a machine determines the expressive elements of the visual output, the resulting work enters the public domain immediately upon generation.
Prompt engineering alone does not satisfy the human authorship standard. Inputting text prompts is legally viewed as giving instructions to a commissioned artist, where the user lacks control over the exact pixels. Copyright requires the expression of an idea, not just the idea itself. Prompts represent the underlying concept, while the artificial intelligence model determines the actual layout, shading, and visual expression. An artist can secure copyright for a hybrid work if they modify the generated output significantly. Manual digital painting, color correction, and structural manipulation introduce the necessary human creative authorship. The law uses a standard called de minimis to evaluate human contributions. If the human modification is trivial, protection is denied. Only substantial, identifiable human additions qualify for a separate copyright.
When submitting a registration application, creators must fulfill the duty of candor. This requires explicitly disclosing the use of artificial intelligence tools and disclaiming the uncopyrightable machine-generated portions. Failure to disclose generative technology can lead to the cancellation of the copyright registration. The office routinely revokes certificates when they discover substantial machine intervention was omitted from the application. Can a corporation own generative outputs via the work-for-hire doctrine? No, because the doctrine requires an employment relationship or written agreement between legal persons, and software holds no legal personhood. Unprotected images fall into the public domain. This means anyone can legally copy, modify, distribute, or commercially exploit purely machine-generated graphics without paying royalties or seeking permission from the prompter. This creates a major commercial risk for video game studios, advertising agencies, and publishers. Competitors can freely replicate branding, concept art, and assets if they are entirely generated by algorithms. Derivative works offer an alternative path to protection. An author can arrange public domain machine images into a unique collage, sequence, or compilation, establishing copyright over the selection and arrangement. The compilation copyright only protects the unique arrangement itself. It gives the creator no exclusive rights to the individual images, which remain free for the public to extract and use independently. The issue becomes more complex with training data. High-profile class action lawsuits by human artists allege that tech companies infringed copyrights by scraping billions of protected images without licenses. Artificial intelligence developers argue that training models constitutes fair use. They claim the process transforms copyrighted inputs into statistical weights to generate entirely new, non-infringing expressive works. Under United States law, fair use is determined by 4 factors, including the purpose of the use, the nature of the work, the amount taken, and the market impact on the original. If an output too closely resembles a specific protected image, it can trigger a claim of substantial similarity. The user who generated it could face direct copyright infringement liability. Major platforms have responded by implementing indemnification clauses. They promise to cover legal fees for commercial users if their generated outputs trigger copyright infringement lawsuits from third-party creators. Legal standards differ globally. For example, the United Kingdom grants copyright to computer-generated works without a human author, attributing ownership to the person who made the arrangements for its creation. This international divergence creates cross-border conflicts. An image unprotected in the United States might enjoy legal exclusivity in foreign jurisdictions, complicating global intellectual property management for digital companies. Traditional camera technology faced similar scrutiny in the 19th century. Critics argued photographs were mechanical reproductions, but courts ruled that camera settings and composition reflected human creative choices. Why is artificial intelligence treated differently than a camera? A camera captures existing physical reality based on human positioning, while generative models generate unpredictable new expressions based on autonomous internal math. The threshold of human control remains the evolving legal battleground. Future legislation may establish a brand new form of intellectual property, a sui generis right specifically tailored for algorithmic creations. Until statutory amendments occur, the core principle remains absolute, without direct, substantial human execution shaping the final expressive details. United States copyright law will continue to deny protection to machine art.
Contractual agreements can protect machine graphics where copyright fails. Companies use terms of service and trade secret protections to restrict the commercial usage of their generated visual assets by competitors. Trademark law offers another alternative strategy. While you cannot copyright an artificial intelligence logo, using that logo consistently in commerce can establish valid trademark rights to prevent brand confusion. Right of publicity laws also intersect with generative art. Creating a highly realistic digital replica of a celebrity or known artist without consent violates state statutes, independent of copyright ownership. The legal distinction between style and expression is critical. You cannot copyright an artistic style. Therefore, instructing a model to mimic a specific living artist's style is generally legal, though ethically controversial.
As technology advances, the boundary between human and tool blurs further. Federal courts and the Copyright Office continually review policies, but the human authorship requirement remains an unyielding statutory pillar.